Washington Journal continues.
And now on your screen is Alicia Green. She is with CQ Roll Call. She covers technology for that publication. She is here to talk about email privacy and law enforcement access to data. Alicia Green, what's the current law when it comes to emails? If you and I emailed each other, are they protected like mail is protected, like postal mail?
Well, they're not, which might surprise a lot of people. There's actually a nearly 30-year-old law from 1986 that outlined how law enforcement could access people's electronic communications. And under this law, if your email has been sitting somewhere for more than 180 days, they don't even need a warrant to access it and read it.
So emails that people have retained for more than 180 days currently are open for business? I mean, for other people to read, correct?
Totally open for law enforcement and government to be able to access those emails. And keep in mind that statute was written at a time when people weren't really storing emails for that long, but obviously things have changed a lot over the past few decades.
What if you and I corresponded via post office? Is that protected?
That is a different standard, you're right. I mean, the Fourth Amendment outlines exactly those kinds of things, but then Congress in the 80s tried to deal with this rising use of technology to communicate, and obviously what they did at that time made sense to them, but things have changed so much as far as how people use email that now people are trying to update that law.
Okay, there's some action in Congress right now on something called the Electronic Communications Privacy Act, ECPA.
Yes.
What is ECPA? And what does it do?
Well, that law is the one from 1986 that outlines when government can access emails. And people are saying this 180-day rule just doesn't make sense anymore. So there are a few bipartisan legislators who have led a movement over the past few years to really try to change this. And there's broad agreement that the 180-day rule just doesn't make sense anymore.
Okay, but you say a few legislators. Isn't more than 300 in the House alone on board with changing the rules?
You're right. So I think it's 305 co-sponsors now on this bill. There were a few that led it and tried actually in the last session to do this as well, but it is just a huge groundswell of support for this change now.
Well, one of the issues that is being addressed by this bill is Representative Ted Poe, a Republican of Texas, spoke about. Here he is.
It makes no sense to me that the right of privacy is protected for 6 months, but it's not protected more than 6 months. Send a letter, snail mail, and I put that in an envelope and I send it off to one of my grandkids somewhere. It floats around in America from post office to post office and who else knows where until it gets to grandson. It's protected. Generally, it's protected. It's a form of communication. When we use emails or store in the cloud, it's a form of communication wherever the cloud may be. So I think it's Congress's responsibility to determine what the expectation of privacy is. It's not, God bless them, federal judges' responsibility. It's Congress's responsibility to say this is an expectation of privacy for Americans. And when we enter the digital age, I don't buy the argument, well, we're in the digital age. You got to give up some of your constitutional rights so we can have government investigate things. Whether it's civil investigation, whether it's criminal investigation, I don't buy it because the Fourth Amendment gets in the way of that. I think it is one of the most important rights that we have. So it's our duty to set up a standard.
What is being proposed for changes in the law?
Well, if your email has been sent, no matter how long it's been around, government will need a warrant to access it. The 180-day mark just doesn't matter anymore. If your emails have been stored for months or years, government will still need a warrant. And there are a few other changes in this bill as well. And some of those changes have a few federal agencies and law enforcement officials concerned, even though they all agree that email should be treated the same no matter how long it's been around.
We're going to put the numbers up on the screen if you want to talk with us and Alicia Green about email privacy and law enforcement access to online data. Here are the numbers. They are on the screen. Go ahead and dial in. What are some of the concerns by other agencies?
So some of the civil agencies, such as the Securities and Exchange Commission, have said we don't have access to a criminal warrant if we need to get at this data for an investigation. So they're concerned this could hinder their investigations of things like financial fraud or trade fraud, things like Ponzi schemes. So some of these agencies are asking for carve-outs to this warrant requirement, essentially, to be able to continue to do their work. And this is something that has seemed to solve the bill from moving forward.
Why, if it's got 300 sponsors in the House, has it not been brought to a vote?
These concerns have certainly caught the attention of House Judiciary Chairman Representative Goodlatte, and he, in a hearing earlier this week, expressed some of the same concerns. He really wants to see a balance struck so that government officials, government agencies can continue to do their investigations when needed.
Let's take some calls. Jean Ann, Madison, Wisconsin, Independent Line. You are on with Alicia Green of CQ Roll Call, talking about email privacy and law enforcement access to that.
Good morning. I think with the state of affairs that's going on in our country at this point in time, we need to give up some things in order to protect ourselves. You know, people talk about vetting. Vetting isn't something that's really going to be an option because everybody has, or many people will have false documentation. You know, everybody's got open arms, welcome everybody. You know, if there's AK-47s next door, I mean, I think we really need to pay attention to the fact that people need to be protected, and I think it's unfortunate that people are talking about gun control as the answer. What about protection of the citizens? I mean, if terrorists want guns, they will always have guns, and if gangsters want guns, they will always have guns, and I can honestly say, you know, drugs get into people's hands and, you know, they're illegal.
All right, Jean Ann, I think we got the point. Giving up some of our rights in today's world is her point.
And you know, that's a good point to bring up. Certainly after the Edward Snowden revelations a few years ago, people had more concerns about privacy, and then how do you balance that with the legitimate needs of law enforcement agencies, given everything else that's going on? So, you know, certainly there are many other laws that ultimately govern how law enforcement can access people's communications, and there are different laws for, you know, for example, the Foreign Intelligence Surveillance Act that also deals with how government can access information for terrorism-related cases. So this bill isn't the only thing that will ultimately deal with how government can access information.
Oscar's in Vienna, Virginia, here in the suburbs. Democrat. Oscar, go ahead.
Yes, hi. Good morning. I'm curious as to why they cannot keep the criminal side of this surveillance active, because I think, for example, the Farouk guy that perpetrated this killing this week, he actually has a sister. I believe they said that he used to shoot or practice shooting in his yard. Why cannot we look into that cell phone that his sister and his mother? I'm curious why the police never went to the grandmother's house. It's interesting. This surveillance should apply to criminal cases, and it's subjective. I mean, the question is, do you believe that there should be more surveillance when it comes to this type of scenario?
Right. I think that's an interesting question. You know, certainly, like I said, there are several other laws that government agencies and law enforcement officials can ultimately use if they do suspect someone of being involved in criminal activity. This proposed legislation in Congress would deal most specifically with emails, and you know, there are other things that deal with stored communications on cell phone devices, and I think ultimately the FBI also has said, you know, there are other ways they can get information if needed.
Teresa's in Lancaster, Pennsylvania, Republican line. Hi, Teresa.
Hi, thank you for taking my call. I have a question about this, the warrants that have to be gotten before information can be accessed. Do the warrants have to be presented to the owners of the information, like the emails or the cell phones? prior to accessing that information? I'll wait for your answer. Thank you.
Yes, thank you. That's a great question, and that is certainly one of the parts of the bill. So actually a warrant or a subpoena would have to be served directly to the individual rather than to a service provider. And the supporters of this legislation say that's really a key element for making sure people know when their information is being accessed.
What's the difference between a warrant and a subpoena?
There are different judicial standards for when those can be issued. And another one of the concerns actually of some of the civil agencies is that they would be required to serve a warrant if they did want to get access to communications directly from an internet service provider. If they'd already tried going to the person who is sending these emails, allegedly involved in a financial scheme, for example, but they didn't think that person was turning over all of the information. Ultimately, if they want to go to the service provider to try to get that information, they need a warrant under this legislation. And so there again, for the civil agencies, that's not something that they have access to, and they'd prefer to be able to go with a court order to get the information.
Harry's in Marble Falls, Texas Independent Line. Please go ahead, Harry. You're on with Alicia Green.
Good morning. Thank you for keeping us appraised of pending legislation. I wonder if your guest could kindly provide us with the letter number description of the House and Senate version of this pending legislation so individuals such as myself could read it for myself and make my own judgments as to how it might be affecting my personal email privacy. And then on the technical side, I am not a Microsoft certified systems engineer or an IT professional, but I often have to retain their services in my line of work. What I personally recommend that everybody listening do, which I am currently easily able to do with my Microsoft Outlook application that I use for my business and personal use, is instead of archiving your old emails with the internet service provider so it's on their server and then accessible to people who can gain access for whatever reason, simply transfer those, set up the rules to your whatever you use to email inbound and outbound to archive into either a file on your personal computer or even better, put them on a CD-ROM. And that way you don't even have to worry about it. Once you set up the rules to only allow you to gain access to anything you have archived because you put it all the way onto a CD-ROM, put the CD-ROM in a safety deposit box if you're that concerned about your privacy. End of problem.
Well, it's an interesting point, and certainly one that, like you said, people might be exploring. And to your first question, if people are interested in looking at these reform bills in Congress, the Email Privacy Act is House Resolution 699, and the Senate version is Senate Bill 256, I believe. So if you want, you can go and read the full text and learn more about what they would do.
What are some of the things we haven't discussed that are in these bills?
Well, certainly, like I said, even the Department of Justice has sort of raised concerns about these really blanket warrant requirements. They have civil litigators who sometimes need a standard like a subpoena to be able to access things because criminal warrants are not available in civil cases.
Dan is calling in from Iron Ridge, Wisconsin, Republican. Hi, Dan.
Hi. I don't know if everybody remembers the NSA taking everybody's information. They grabbed that without a warrant. Their next move is to pull our rights, most of our rights for guns. They should be going after terrorists. They shouldn't be going after the American people. And I just don't think it's right. It's all about government control, and it's just something that I find sad in America today. And thank you for your time.
Any response for that caller, Alicia Green?
Well, like you mentioned, certainly the NSA has its own capabilities that would not be touched on by these bills going through Congress. But with more than 300 co-sponsors for the House bill, there's a lot of agreement that some basic changes need to be made about how we treat emails in general.
Kevin, well, before we get to Kevin, are there does this Electronic Communications Privacy Act fit into any larger legislation, or is it pretty much a standalone looking specifically at emails?
The Stored Communications Act is actually within the Electronic Communications Privacy Act. There are a couple different layers here of electronic communications that these bills would deal with. But actually, that's one of the things that's caused confusion so far in applying these current laws. The courts have interpreted some of these fairly old phrases pretty differently. It refers to things like data stored remotely, and now that everyone is using the cloud to sort of store emails, people really want more clarity in the law as it is.
And right now, cloud is not very clear as to where it falls in the legal world?
There are several different interpretations in courts around the country about what some of the various phrases mean, and this has caused real concerns for law enforcement.
Kevin's in Blackwood, New Jersey, Democrat. Hi, Kevin.
Hi, how you doing this morning? Yeah, thanks for talking about this issue. One of the things that's more concerning to me, besides the government, the privacy, is the multi-billion-dollar industry that private corporations and that not only email, but the databases that are have been developed for years, and the information that's being used, on identifying specific traits on people and how they're used in corporations and private interests. And there doesn't seem much legislation, much concern or talk about that issue. I think that's sort of goes along with the government issue as well.
Sure, you bring up an interesting point. There is a lot of data collection on U.S. people that isn't led by the government or law enforcement. Companies certainly collect a lot of information when people are browsing around online or even using their cell phones to access different things. I don't personally know of legislation aimed at dealing with that, but I'm sure that's something that people on the Hill are also thinking about.
Judy is calling in from Lahaina, Hawaii. Hi, Judy.
Hi, how are you tonight? I guess it's this morning there, so night here. I have a couple of questions. Who is putting out this? This is not the NSA email law that was in existence. This is a new law. This is a new bill. And what is the purpose of the government wanting to read our emails? Is this related to what the NSA is reading our emails also, or?
Thank you, Judy. Let's get an answer from our guest. First of all, the NSA. What have they done in the past? What's the role of Edward Snowden? Does this affect the NSA?
Well, the short answer to the last part of your question is no. Based on my understanding, this does not ultimately impact the NSA and its abilities. This really deals more with federal agencies such as DOJ and some of the civil agencies I mentioned earlier. The SEC, the FTC would be impacted. The NSA's abilities are governed under different laws, as far as I know, and those would not be impacted by these bills that we're talking about. But certainly, like I said, the Snowden revelations from a few years ago increased people's awareness of the different ways that government can access information, and it certainly raised the tech companies' awareness, or I guess willingness to talk about it, to a level where they've raised a lot of concerns and have said, privacy is a key thing for us. They're supporting these bills as well.
Well, you talked about the fact that 300 plus members in the House. What about in the Senate? Where does it stand in the Senate?
There are a significant number of co-sponsors there for the similar legislation as well.
Okay, but you said that Judiciary Committee Chair Bob Goodlatte, Republican of Virginia, has concerns. One of his statements: one of the goals of this legislation is to treat searches in the virtual world and the physical world equally, so it makes sense that the exceptions to the warrant requirement should also be harmonized. It is well-settled law that the government may conduct a search in the absence of a warrant in certain instances, including when the government determines that an emergency exists requiring the search, or when the government obtains the consent of the owner of the information.
Mm-hmm. And that's one of the concerns that law enforcement officials have brought up with this legislation. They've said there aren't clear exceptions for when we would be required to have a warrant. Cases of missing or abducted children, for example, they're worried that they could have to go through this warrant process and they could be too late with accessing the information they need.
Travis, Lake in the Hills, Illinois, Democrat, please go ahead. We're talking about email privacy.
Hi, good morning. So a caller earlier was talking about giving up some rights, and I've been hearing a lot of people kind of hinting towards that, and it's pretty alarming. Like, the poor people in America have literally been invited to the table to help shape our country with the upper class. And to talk about rights of giving sort of things like that up is frightening. I don't understand how people would come to those kind of conclusions, that these are actual solutions.
I think there's certainly a heightened discussion now about the balance between people's privacy rights, especially under the Constitution and the Fourth Amendment in this case, and how we continue to deal with different threats. So, certainly this is something that people have been talking about a lot in the past few years, and there's sort of these incremental efforts to protect privacy while balancing the need to access information in certain cases.
And Jim in Glen Cove, New York, independent line. Please go ahead with your question or comment for Alicia Green.
Yeah, hi. I'm just curious. How did we get to the point where we had to spend so much money, and I say we, the taxpayers, to get Hillary's emails? I know this isn't the topic, but she was the one that's, you want to know about my business, I want to know about her business because she's lied to us so many times now. Can you help me out with that?
Any comment for that caller, Alicia Green? Is that something that you have covered at all?
That's not something I've covered in depth. I think her servers were sort of different from what's being dealt with ultimately in this bill.
All right, so Electronic Communications Privacy Act, give us the basics again. How old is it? What's being proposed? What's holding it up?
Right, so we have a law that's almost 30 years old at this point and tried to outline when government and law enforcement could access people's emails and electronic communications. Now people are saying that's pretty outdated. Any emails over 180 days old shouldn't just be open for people to read. So now they're eliminating that standard. They're saying no matter how old your email is, government needs a warrant. That's really the gist of the bill that people across the board have been able to agree on. It's some of the other nuances that the legislation touches on that have caused it to, so far, not be able to move forward to a House vote.
So that's what's being proposed, to change that 180-day rule. 300 plus co-sponsors in the House, many in the Senate, and it has not moved forward at this point because some of the issues that we've discussed.
Correct, but we could still see it move forward. Certainly it's something that could happen in the early part of next year. It has a number of co-sponsors, and it sounds like they really are working on coming to some sort of an agreement on what language might be useful to protect people's privacy, but still allow certain exceptions.
And is this just emails? Are we including texts? Are we including private messaging services at this point? Where those fall?
Sure. Well, like I said, the Stored Communications Act is something that falls under this broader law. So there are a few different types of electronic communications that are ultimately dealt with in different ways. And there are different levels of details about what they can access. For emails, it would be the full content. For other communications, it might just be who sent a message to who and when. But ultimately, those things are also impacted by things like encryption. When can you actually get to the content of those communications?
Alicia Green is with CQ Roll Call. We've been talking about email privacy and law enforcement access to data. Thanks for your time.
Thank you.
One more segment coming up this morning on the Washington Journal, and we're going to be looking at school crime, violence, and safety.
I'm the leading state sponsor of terrorism.